Hello students, welcome to EPG Pathshala, Paper 12 Environmental Management, Module 10 EIA Notification 2006-2. Dear students, Part 1 of this EIA Notification 2006 we have already discussed in the previous module number 9, and out of the 12 paragraphs, some paragraphs we have already discussed in the previous module. So, continuing from the previous module, this module will have the contents: number 1, application for prior environmental clearance, stages in the prior environmental clearing process for new projects 7.1, then stages in the environment clearance process for new projects, prior environment clearing process for expansion or modernization or change of product mix in existing projects. Then grant or rejection of prior environment clearance, validity of environmental clearance, then post environmental clearance, monitoring, transferability of environment clearance, operation of EIA notification 1994 till disposal of pending cases, etc. So, little introduction of this module. As I described, this is in continuation to the previous session where the history, genesis and summary of EIA notification have been covered. The previous session also covers the first 5 points or paragraphs of the notification along with the schedule and appendix 6, which is composition of the sector project specific expert appraisal committee for category A projects and the state or UT level expert appraisal committees for category B projects to be constituted by the central government. The present session covers the remaining 6 to 12 points or paragraphs of the said notification along with the relevant appendices. The appendices discussed in these are: Appendix 1, it contains the prescribed Form 1 for seeking prior environmental clearance in all cases. Appendix 2 contains Form 1A, required only for construction projects listed under item 8 of the schedule. Appendix 3, generic structure of environmental impact assessment document. Then Appendix 3A, contents of summary environmental impact assessment. Then Appendix 4, procedure for conduct of public hearing. Appendix 5, procedure for appraisal. Starting with application for prior environmental clearance. An application shall be made in the prescribed Form 1 annexed in this notification and supplementary Form 1A if applicable as given in the Appendix 2 after the identification of prospective site for the project and or activities to which the application relates before commencing any construction activity or preparation of land at the site by the applicant. The applicant shall furnish along with the application a copy of the pre-feasibility report, except that in case of construction projects or activities, that is which are under item 8 of the schedule, in addition to Form 1 and the supplementary Form 1A, a copy of the conceptual plan shall be provided instead of pre-feasibility report. Next, stages in the prior environmental clearance process for new projects. As per this notification, the environment clearance process for new projects will comprise of a maximum of 4 stages, all of which may not apply to particular cases as set forth in this notification. The 4 stages in the sequential order are: stage 1, which is screening. It is required only for category B projects and activities. Stage 2, scoping stage. Stage 3, it is public consultation, and then stage 4, final decision. So, discussing stage 1, appraisal. Screening in case of category B projects or activities. This stage will entail the scrutiny of an application seeking prior environmental clearance made in Form 1 by concerned state level expert appraisal committee for determining whether or not the project or activity requires further environmental studies for preparation of an environment impact assessment for its appraisal prior to the grant of environmental clearance, depending on the nature and location specificity of the projects. The projects requiring an EIA report shall be termed category B, and the remaining projects shall be termed category B and will not require an EIA report. For categorization of projects into B1 or B2, except item 8B, the Ministry of Environment and Forests issues appropriate guidelines from time to time. Then stage 2, scoping. Scoping refers to the process by which the expert appraisal committee in case of category A projects or activities and state level expert appraisal committee in case of category B1 projects or activities, including applications for expansion and or modernization and or change in product mix of existing projects or activities, determine detailed and comprehensive terms of reference, commonly called TOR, addressing all relevant environmental concerns for the preparation of an environmental impact assessment report in respect of the project or activity for which prior environmental clearance is sought. The expert appraisal committee or state level expert appraisal committee concerned shall determine the terms of reference on the basis of the information furnished in the prescribed application form 1 or 1A, including terms of reference proposed by the applicant. A site visit by the subgroup of expert appraisal committee or state level expert appraisal committee concerned only if considered necessary by the expert appraisal committee or state level expert appraisal committee concerned. Terms of reference suggested by the applicant if furnished and other information that may be available with the expert appraisal committee or state level expert appraisal committee concerned. All the projects and activities listed in category B in item 8 of the schedule, that is construction, township, commercial complexes, housing, shall not require scoping and will be appraised on the basis of Form 1 or Form 1A and conceptual plan. The terms of reference shall be conveyed to the applicant by the expert appraisal committee or state level expert appraisal committee as concerned within 60 days of the receipt of Form 1. In case of category A hydroelectric projects, that is item 1C1 of the schedule, the terms of reference shall be conveyed along with the clearance for pre-construction activities. Further, if the terms of reference are not finalized and conveyed to the applicant within 60 days of the receipt of Form 1, the terms of reference suggested by the applicant shall be deemed as the final terms of reference approved for EIA studies. The approved terms of reference shall be displayed on the website of the Ministry of Environment and Forests and the concerned state level Environment Impact Assessment Authority. Applications for prior environmental clearance may be rejected by the regulatory authority concerned on the recommendations of the EAC or SEEC concerned at this stage itself. In case of such rejection, the decision, together with reasons for the same, shall be communicated to the applicant in writing within 60 days of the receipt of the application. Stage 3. Public consultation. Public consultation refers to the process by which the concerns of local affected persons and others who have plausible stake in the environmental impacts of the project or activity are ascertained with a view to taking into account all the materials, concerns in the project or activity design as appropriate. All category A and category B1 projects or activities shall undertake public consultation except number 1, modernization of irrigation projects, which comes under item 1C2 of the schedule. All projects or activities located within the industrial estates or parks, that is item 7C of the schedule, approved by the concerned authorities and which are not disallowed in such approvals. Expansion of roads and highways, that is item 7F of the schedule, which do not involve any further acquisition of land. Then all building and construction projects or area development projects and townships under item 8 of the schedule. All category B projects and activities, all projects or activities concerning national defense and security or involving other strategic considerations as determined by the central government. Further, the process of public consultation. The public consultation shall ordinarily have two components comprising of number 1, public hearing at site or in its close proximity district wise, to be carried out in a manner prescribed in the appendix 6 of the notification for ascertaining concerns of local affected persons, obtain responses in writing from other concerned persons having a plausible stake in the environment aspects of the project or activity. The public hearing at or in close proximity to the site in all cases shall be conducted by the State Pollution Control Board or the Union Territory Pollution Control Board concerned in the specified manner and forwarded the proceedings to the regulatory authority concerned within 45 days of a request to the effect from the applicant. In case the State Pollution Control Board or the Union Territory Pollution Control Committee concerned does not undertake and complete the public hearing within the specified period and or does not convey the proceedings of the public hearing within the prescribed period directly to the regulatory authority concerned as above, the regulatory authority shall engage another public agency or authority which is not subordinate to the regulatory authority to complete the process within a further period of 45 days. If the public agency or authority nominated under the subparagraph 3 of the notification above reports to the regulatory authority concerned that owing to the local situation, it is not possible to conduct the public hearing in a manner which will enable the views of the concerned local person to be freely expressed, it shall report the facts in the detail to the concerned regulatory authority, which may, after due consideration of the report and other reliable information that it may have, decide that the public consultation in the case need not include the public hearing. For obtaining responses in writing from other concerned persons having a plausible stake in environmental aspects of the project or activity, the concerned regulatory authority and the State Pollution Control Board or the Union Territory Pollution Control Committee shall invite responses from such concerned persons by replacing on their website the summary of EIA report prepared in the format given in the appendix 3 of the notification by the applicant along with a copy of application in the prescribed form within 7 days of receipt of a written request for arranging the public hearing. In the public hearing, the confidential information including non-disclosable or legally privileged information involving intellectual property right, source specified in the application shall not be placed on the website. The regulatory authority concerned may also use other appropriate media for ensuring wide publicity about the project or activity. The regulatory authority shall, however, make available on a written request from any concerned person the draft EIA report for inspection at a notified place during normal office hours till the date of public hearing. All the responses received as part of this public consultation process shall be forwarded to the applicant through the quickest available means. After completion of the public consultation, the applicant should address all the material environmental concerns expressed during the process and make appropriate changes in the draft EIA and EMP. The final EIA report so prepared shall be submitted by the applicant to the concerned regulatory authority for appraisal. As per notification, the applicant may alternatively submit a supplementary report to draft EIA and EMP addressing all the concerns expressed during the public consultation. The stage 4 is appraisal. Appraisal means the detailed scrutiny by the expert appraisal committee or the state level expert appraisal committee of the application and other documents like the final EIA report, outcome of the public consultations, including public hearing proceedings, submitted by the applicant to the regulatory authority concerned for grant of environmental clearance. This appraisal shall be made by expert appraisal committee or state level expert appraisal committee concerned in a transparent manner in a proceeding to which the applicant shall be invited for furnishing necessary clarifications in person or through an authorized representative. On conclusion of these proceedings, the expert appraisal committee or state level expert appraisal committee concerned shall make the categorical recommendations to the regulatory authority concerned either for the grant of prior environmental clearance on stipulated terms and conditions or rejection of the application for prior environmental clearance together with reasons for the same. Further, the appraisal of all projects or activities which are not required to undergo public consultation or submit an EIA report shall be carried out on the basis of the prescribed application form 1 and form 1A as applicable, any other relevant validated information available, and the site visit wherever the same is considered as necessary by the expert appraisal committee or the state level expert appraisal committee concerned. The appraisal of an application be completed by the expert committee or state level expert appraisal committee concerned within 60 days of the receipt of final environment impact assessment report and other documents or receipt of form 1 and form 1A, where public consultation is not necessary, and recommendation of the state expert appraisal committee, whereas public consultation is not necessary and the recommendations of the expert appraisal committee or state level expert appraisal committee shall be placed before the competent authority for a final decision within the next 15 days. The prescribed procedure for appraisal is given in Appendix 5 of the said notification. Prior environment clearance process for expansion or modernization or change of product mix in existing projects. All applications seeking prior environmental clearance process for expansion with increase in the production capacity beyond the capacity for which environment clearance process have been granted under this notification or with increase in either lease area or production capacity in case of mining projects or the modernization of an existing unit with increase in total production capacity beyond the threshold limit prescribed in the schedule to this notification through change in process and or technology or involving a change in the product mix shall be made in form 1 and they shall be considered by the concerned expert appraisal committee or state level expert appraisal committee within 60 days, who will decide on the due diligence necessary, including preparation of EIA and public consultations, and the application shall be appraised accordingly for grant of environmental clearance. Next, grant or rejection of prior environmental clearance. The regulatory authority shall consider the recommendations of the EAC or SEAC concerned and convey its decision to the applicant within 45 days of the receipt of the recommendations of the expert appraisal committee or state level expert appraisal committee concerned, or in other words within 105 days of the receipt of final environment impact assessment report, and where environment impact assessment is not required within 105 days of the receipt of complete application with requisite documents, except in some cases where the regulatory authority shall normally accept the recommendations of the expert appraisal committee or state level expert appraisal committee concerned. In cases where it disagrees with the recommendations of the expert appraisal committee or state level expert appraisal committee concerned, the regulatory authority should request reconsideration by the expert appraisal committee or state level expert appraisal committee concerned within 45 days of the receipt of recommendations of the expert appraisal committee or state level expert appraisal committee concerned, while stating the reasons for the disagreement. An intimation of this decision shall be simultaneously conveyed to the applicant. The expert appraisal committee or state level expert committee concerned in turn shall consider the observations of the regulatory authority and furnish its views on the same within a further period of 60 days. In the event that the decision of the regulatory authority is not communicated to the applicant within the period specified in the subparagraphs 1 or 2 of this notification as above as applicable, the applicant may proceed as if the environment clearance sought for has been granted or denied by the regulatory authority in terms of final recommendation of the expert appraisal committee or state level expert appraisal committee concerned. Further, on expiry of the period specified for decisions by the regulatory authority under paragraph 1 and 2 as applicable, the decision of the regulatory authority and the final recommendations of the expert appraisal committee or state level expert appraisal committee concerned shall be public documents. Clearance from other regulatory bodies or authorities shall not be required prior to receipt of applications for prior environmental clearance of projects or activities or screening or scoping or appraisal or decision by the regulatory authority concerned, unless any of these is sequentially dependent on such clearance either due to requirement of law or for necessary technical reasons. Further, deliberate concealment and or submission of false or misleading information or data which is material to screening or scoping or appraisal for decision on the application shall make the applicant liable for rejection and cancellation of prior environmental clearance granted on that basis. Rejection of an application or cancellation of a prior environmental clearance already granted on such ground shall be decided by the regulatory authority after giving a personal hearing to the applicant and following the principles of natural justice. Validity of environmental clearance. The validity of environmental clearance is meant the period from which a prior environmental clearance is granted by the regulatory authority or may be presumed by the applicant to have been granted under subparagraph 4 of the paragraph 7 of this notification to the start of production operations by the project or activity or completion of all construction operations in case of construction projects to which the applicant for the environmental clearance refers. The prior environmental clearance granted for a project or activity shall be valid for a period of 10 years in case of river valley projects. Item 1C of the schedule. Project life as estimated by the expert appraisal committee or state level expert appraisal committee subject to a maximum of 30 years for mining projects and 5 years in case of all other projects and activities. However, in case of area development projects and townships, the validity period shall be limited only to such activity as may be the responsibility of the applicant as a developer. This period of validity may be extended by the regulatory authority concerned by a maximum period of 5 years, provided an application is made to the regulatory authority by the applicant within the validity period, together with an updated Form 1 and supplementary Form 1A for construction projects or activities. In this regard, the regulatory authority may also consult the Expert Appraisal Committee or State level Expert Appraisal Committee as the case may be. Then, post environmental clearance monitoring. As per notification, it shall be mandatory for the project management to submit half-yearly compliance reports in respect of the stipulated prior environmental clearance terms and conditions in hard and soft copies to regulatory authority concerned on 1st June and 1st December of each calendar year. All such compliance reports submitted by the project management shall be public documents. Copies of the same shall be given to any person on application to the concerned regulatory authority. The latest such compliance report shall also be displayed on the website of the concerned regulatory authority. Next, discussing the transferability of environmental clearance. A prior environmental clearance granted for a specific project or activity to an applicant may be transferred during its validity to another legal person entitled to undertake the project or activity on application by the transferor or by the transferee with a written no objection by the transferor to and by the regulatory authority concerned on the same terms and conditions under which the prior environmental clearance was initially granted and for the same validity period. No reference to the Expert Appraisal Committee or state level Expert Appraisal Committee concerned is necessary in such cases. Finally, the last paragraph of this notification, since the notification was the replacement of notification 1994 and at the notification of this 2006 notification, some cases under the 1994 were pending. Hence, a paragraph relating operation of EIA notification 1994 till disposal of pending cases from the date of final publication of this notification came. The Environment Impact Assessment Notification number SO 60E dated 27 January 1994 is hereby superseded, except in suppression of the things done or omitted to be done before such supersession to the extent that in case of all or some type of applicants made for prior environmental clearance and pending on the date of final publication of the notification, the central government may relax any one or all provisions of the notification except the list of the projects or activities requiring prior environmental clearance in Schedule 1 or continue operation of some or all provisions of the notification for a period not exceeding 1 year from the date of notification of not exceeding 1 year from the date of issue of this notification. So, dear students, in the end, concluding that the notification EIA notification 2006 has superseded the EIA notification 1994. This notification 2006 has made many amendments and many changes in the EIA notification 1994. This is a more transparent and clear process, and this has come a long way from 1994 to 2006. Thank you.